ASIL. We are a 112-year-old professional membership association, primarily for international lawyers, although we have active members who are in a bunch of different disciplines, including historians, poli-sci, economics, international relations, and the like. As part of ASIL's non-advocacy and nonpartisan mission, we cooperate with a lot of our academic partners and other entities on providing access to leading figures in international law and international issues for the education and information around these topics. And this is, I believe, the 7th year now that we've been doing this series with the Academy on Human Rights and International Humanitarian Law at AU. We're very excited to continue that series with the final of the 3 parts today. But I did want to mention just 2 brief things before we actually get going on the substance. First, right now on the ASIL website at asil.org/MYM for mid-year meeting, calls are open for abstracts for the research forum. ASIL's research forum happens in the fall every year. It's a collection of nearly 100 papers that are presented by scholars, practitioners, government attorneys, private practice attorneys on any international law topic, including interdisciplinary ones. It moves around the country every year. It takes place in a different location. This year it will be in Los Angeles at UCLA. And the intent behind it is to allow scholars, whether they be students or senior practitioners, to present a paper to an informed and educated audience and get feedback on concepts and the like before they go to publication. So the only requirement about the abstracts, other than they must be around an international law topic or at least touch on that, is that they cannot yet have been published. The intent is that it's a works in progress conference. If you're interested in that, the deadline for submitting abstracts is June 24th or 5th, whatever that Monday is. So I would encourage you to do that. It's a blind review process, so no one, in fact, Janie served as the co-chair of the research forum when it was held at AU.
It is blind.
So no one knows who is, in fact, I'm the only person who actually knows the names of the applicants until we make the selection and decide on who's going to be presenting their papers. It is competitive. We usually have about 200 applications for about 70 spots. But it's a wonderful opportunity to get your research in front of some of the prominent figures of international law. And if you're interested in getting your ideas evaluated by those kinds of people, it's a great opportunity. The other thing that I'll mention is our annual meeting, which we just finished, not like 6 or 7 weeks ago. But we are in the process of actually recruiting proposals for sessions for next year's annual meeting, which will be held in March 27th through the 30th in 2019. This is a very different kind of thing. This is not paper presentations. The annual meeting is substantive panels around different topics. There's a theme for the meeting, which is this year international law as an instrument, how it is used in pragmatic ways in international legal institutions, in politics, in global relations, and things along that line. And we recruit panel ideas for the substantive topics to be discussed from the broader community. So our members and non-members tell us what they think we should be talking about during the annual meeting. And so we'd be interested in having any of you submit ideas for those kind of session discussions as well. This is a little bit different in that you don't have to write up an abstract. It can literally be, and sometimes I've seen proposals that come in that just say, this decision came down from an international court, you guys should have a panel that talks about it. I want to know more about it. So it can be very brief, but if you have topics that you think deserve the attention of the society and the broader international law community, the annual meeting is a great place to get those elevated. It sets the conversation for the international law community for a year. And it's a great way to engage with these issues. With that said, I'll turn things over to Claudia to make some introductions and to introduce our panel.
My name is Claudia Martini. I'm the co-director of the Academy on Human Rights and Humanitarian Law, together with my colleague Diego Rodriguez Pinzon. We organize every year a program of advanced studies on human rights and humanitarian law, and we have the pleasure to invite to teach in this program a number of experts in every field, including international human rights and international humanitarian law. And Dubraska and Fausto are no exception among these fabulous experts that we bring every year. And so we have partnered for 7 years now with the American Society of International Law to hold this human rights speakers series. We usually have 3 panels, and this is in 2018, this is the 3rd panel. And we are delighted that the topic is on violence against women. This is a topic that we cover and discuss very much, as an institution in American University and of course during the summer program of the Academy. So I want to thank Wes and the American Society of International Law for hosting us one more year, and we hope to continue the cooperation for the future. And now I'm going to leave the floor in the hands of my dear colleague, Professor Jenny Chuang, who is herself an expert in violence against women and trafficking. And we have the honor to share we're colleagues at the law school, and we are delighted that she's here to moderate the panel. So, Jenny?
Thank you so much, Claudia. And thank you to the Academy for hosting this panel with this fabulous group of panelists. So it's my great privilege to be moderating this panel tonight on violence against women, the impact of international law on the protection of victims. As Claudia mentioned, we have with us 2 luminaries in international law. We have Dr. Dubravka Simonovic, the current UN Special Rapporteur on Violence Against Women, Its Causes and Its Consequences, and Judge Fausto Pocar, formerly with the ICTY and ad hoc judge with the ICJ, among many other titles, which I will get to when I read their bios at the end of my intro. So I thought I would start off the panel by throwing out some ideas to frame the discussion a little bit. And then I'll read their brief biographies for our speakers, our very, very impressive speakers. And then in terms of the format of the panel, what we decided was that they would begin with some prepared remarks, but then right after that we would go into question and answer mode. I've prepared a few questions to ask, but I would also invite our panelists to pose questions to each other, and to invite the audience to also pose some questions, because I think it's perhaps more fun to have a conversation, and we can cover a lot more ground that way, I think. So as many of you probably likely know, multiple human rights instruments address states' obligation to protect women against violence, including the Universal Declaration of Human Rights, the International Covenant on Economic, Social, Cultural Rights, the Covenant on Civil and Political Rights, CEDAW, of course, Torture Convention, Migrant Workers Convention. The list goes on and on. The CEDAW Committee's work, which Dr. Simonovic has been at the chair of before, and very much involved in for many years, through the General Recommendation 19, and cases considered via the communications procedure established under the optional protocol to CEDAW, has helped to clarify how the fact that violence against women impairs or nullifies the enjoyment of women of human rights and fundamental freedoms, how that impairment is a form of discrimination itself under CEDAW, and whether that violence is perpetrated by a state actor or a private citizen, and whether it's in public life or in private life. International criminal tribunals have obviously addressed the issue of violence against women, as Judge Pocar will speak to us about, in the cases brought before those tribunals. Yet there remain significant gaps, law and policy gaps in protections against violence. One that immediately comes to mind given recent events. Last week, the International Labor Organization convened its labor conference, at which they discussed the possibility of developing an instrument to deal with gender-based violence in the workplace. And in light of that, we've seen some advocacy around gender-based violence in the workplace. Women's rights groups and sector-specific labor rights groups and unions have made significant strides in calling attention to gender-based violence in the workplace. Yet, as noted by the World Bank's Women, Business, and the Law report of 2018, 59 out of 189 countries whose economies were studied had no specific legal protections covering sexual harassment in employment, for instance. And just last week, a series of reports from a new organization, the Global Labor Justice, and a global coalition of trade unions, workers' rights, and human rights organizations detailed extensive gender-based violence claims and patterns in the garment supply chains of Walmart, The Gap, and H&M, for instance, among other large companies. And so that I raise that issue as an example of an area where law and policy gaps, huge law and policy gaps, still exist. And so we are still in the process of identifying areas that require more standard setting. And the ILO is currently in debate over whether or not that standard setting will take the form of a convention, a binding treaty, or if it will take the form of something softer, more in the way of guidance to states. So even where we do have laws and policies that have been promulgated to address violence against women, as Dr. Simonovic and the previous UN Special Rapporteurs on Violence Against Women have noted, there remains lack of full appreciation and acceptance of international and regional human rights norms and standards on violence against women. So for today's panel, what we're going to explore, as the title suggests, is why this is, how this is so, and what's to be done about it. For those of you who aren't already aware of Dr. Simonovic and Judge Pokar's backgrounds, I'm just going to start with some brief bios. So Dr. Simonovic is, as I said, the UN Special Rapporteur on Violence Against Women. She was appointed to that position in June of 2015 by the UN Human Rights Council. Prior to this, Dr. Simonovic was a member of the Sedo Committee between 2002 and 2014 and served as its chair in 2007 to 2008. During her diplomatic career, she chaired the UN Commission on the Status of Women, and at the European level, she co-chaired the Council of Europe Ad Hoc Committee that elaborated the Istanbul Convention, which is the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. Dr. Simonovic holds a PhD in family law from the University of Zagreb. She is the author of several books and articles on women's rights and violence against women. She's currently a visiting professor in practice in the Center for Women, Peace, and Security at the London School of Economics. We also are very privileged to have Judge Fausto Pokar with us today. He's the Professor Emeritus of International Law at the Law Faculty of the University of Milan, where he has also served as Dean of the Faculty of Political Sciences and as Vice Rector. Since 2012, he has served as the president of the San Remo International Institute of Humanitarian Law. Appointed, when he was first appointed on February 1st of 2000 to the ICTY, he was also and in that position, he's served as the longest-serving judge of the ICTY and was its vice president from 2003 to 2005, and its president from 2005 to 2008. He's also served as judge ad hoc to the ICJ in the cases of Belgium versus Switzerland in 2011 and Ukraine versus the Russian Federation in 2017. For the United Nations, Judge Pokar has served as the chairman and rapporteur of the Human Rights Committee under the ICCPR and as special representative of the UN High Commissioner for Human Rights for visits to Chechnya and the Russian Federation. Judge Pokar is also the author of hundreds of publications on international law, human rights and humanitarian law, and international criminal law, and in yet even more areas of expertise on private international law and European law. In 2014, he was awarded the Great Cross Knighthood by the President of the Italian Republic. So with those introductions, I'm going to invite our speakers to give their remarks before we turn to questions for our speakers. So,
Thank you. Thank you for this introduction, and good afternoon to all. Let me start by thanking American Society of International Law and Academy on Human Rights, Claudia and Diego as vice deans, for inviting me to participate in this important panel. At the beginning, I would like to introduce my mandate of UN Special Rapporteur on Violence Against Women, its causes and consequences, as a mandate that was established in order to send a message that violence against women is a human rights violation and should be addressed within human rights framework. So this mandate was established in 1994, 24 years ago. And up to now, 3 special rapporteurs prior to my appointment established very good framework related to work of the mandate in terms of different thematic report, country-specific reports. And by that work, it was clear that there are numerous challenges. You have already mentioned that in front of us, we are seeing violence against women as widespread, systematic, happening in all countries, all over the world. Numbers are shocking. Me Too campaign was revealing that numbers are really shocking, but we still do not have clear, reliable numbers. We have estimations. Every third woman is a victim of violence, every whatever number is there, it's not really fully reliable number. So we have to see how to use international law and regional treaties related to women's rights and violence against women and all other human rights instruments in order to prevent violence against women. My mandate is providing specific work in this area in terms of possibilities to visit countries. And I have possibility each year to go to up to 2 or 3 countries, and to produce country-specific reports. I'm also invited by United Nations Human Rights Council to produce thematic report, and also another thematic report per year to General Assembly. So from 2015, when I started, I was looking back on work done by my predecessors, and I was then trying to decide what would be added value in terms of challenges in front of us in this area of violence against women. And I had one immediate challenge that was addressed by my predecessor, Ms. Rashida Manjoo. In her last report, she presented the view that there is a lack of legally binding treaty on violence against women at a global level. So she presented the view that there is a need for new global instrument on violence against women. When I started my work as a mandate holder, I have started from that point, and I have decided to invite all other global and regional independent mechanisms that are comparable to my mandate, Sedo Committee, MSECWI that is dealing with implementation of Belém do Pará Convention at Latin American level, to invite Grevio Committee that is dealing with implementation of the Istanbul Convention that was mentioned as a new European Convention on Violence Against Women and Domestic Violence. I have also invited a working group on discriminatory laws that is another special procedure established by Human Rights Council, and also African Commission on Human Rights and Commission on Women's Rights and the Inter-American System to send me their views. At that level, I have decided that it is important to have views from different monitoring mechanisms that are operating under international treaties, be it global or regional, that are already there, to see their perspective. And it was already mentioned that I was in the Sedo Committee, so I had a Sedo perspective, but nevertheless I received official Sedo perspective. And what was the difference between my views and my predecessors' views was that I have had good knowledge about the work of Sedo Committee in this area. And it was clear that under the Convention on the Elimination of All Forms of Discrimination Against Women, from 1992, and General Recommendation on Violence Against Women that you have mentioned, significant work was done with respect to violence against women, and all states that are state party to Sedo that reported also on issues related to violence against women. Also, jurisprudence was developed in the area of violence against women, and this was important to see that we already have a process that was ongoing. So there is important to acknowledge things that have been achieved. The same was important for the regional level, because it was important to see jurisprudence coming from Latin American system, European system, African system, all those important cases that are pointing to specific concrete cases of violence against women and lack of accountability with respect to state and prevention of different forms of violence. So basically, I have requested those views, I have received views, and I must admit that it was not very conclusive, because it was not yes or no answer. But basically, it was clear that there was recognition that at this stage we should be very cautious. We have to see what we have and what is achievable in terms of this idea of embarking on elaboration of new instruments. It is like having an old car that is still driving, that you can reach different distances, but you are not using it properly, or having a new, brand new car. It's questionable if it is affordable, because it is questionable what states will do in terms of support of high-level standards that are needed in this area. So there are plus and cons. And then also I have invited non-governmental organizations and academicians to send me their views. And I have received more than 292 inputs from different stakeholders. And based on that, I have produced a report, to cut it short, in which I have concluded that at this stage, the main problem is a gap between the norms that we have and their implementation. So there is real focus on implementation, implementation, and implementation. And in the meantime, Sedo Committee also adopted new general recommendation number 35 on gender-based violence against women, and my mandate was invited to participate in that process. And this was the first time that special procedure, mandate holder, my mandate, and treaty body like Sedo Committee jointly worked on a general recommendation that is dealing with violence against women. And this was a good way of cooperation, because in my work I'm using Sedo Convention, general recommendations, declaration on elimination of violence against women, and regional mechanisms. And it was important then to have a possibility to express views and to work with Sedo Committee members in direction of influencing the final outcome. Currently, this new General Recommendation 35 is a very modern one. It's expressing all developments that happened from '92 up to now, and it's at the level of the detailed norms that are at the level of Council of Europe Convention on Elimination of Violence Against Women and Domestic Violence, and Belém do Pará. Both conventions we used as inspiration for this General Recommendation 35. I don't want to prolong further, but on this area of framework, it is clear that we do have a strong global and regional set of mechanisms and monitoring bodies. We do have weak implementation, and we have, let's say, those monitoring bodies in position that would need better support from different stakeholders in terms of support by staff or financial resources, because at this stage there is a lot of money going around in this area. There is a lot of talk about violence against women and women's rights, but still regular mechanisms do not receive sufficient support for work that they are doing and that could and should be done. Next week in Geneva, I'm going to present my thematic report. And this is new area. My thematic report is addressing online violence against women, or ICT facilitated violence against women. So we have to see that in this area we do have so many challenges, and you have mentioned harassment and what is now addressed by ILO. And it is important for us all the time to see what is coming up as those new challenges in this area of digital world, cyber world. We have to really be cautious, and now it is clear that at level of national legislation there are different challenges. There are different forms of online violence that are not criminalized properly in a number of countries. Let me mention so-called revenge porn, or non-consensual distribution of intimate images. This is something that is happening in many parts of the world, but only few countries now have adopted new pieces of legislation to send a clear message that this is a criminal offense. So we have to see how to support other countries to go in that direction, but to do it in a manner that is compatible with norms of international law, with Sedo and other treaties that are there, because freedom of information should be preserved, right to privacy is important, and also elimination of violence against women. My next report is going to address violence against women in politics. I have already produced a report on femicides or gender-related killings of women, and report on shelters and protection orders. So I will stop here, and I hope that we will have discussion around issues of your interest. Thank you.
Thank you. I too want to express my gratitude to Claudia and Diego for organizing this meeting together with the ASIL. And it's always a pleasure to participate in these debates here. I will take, I'm tempted to jump on something that my colleague has said, because it brings me back to the times in which I was in the Human Rights Committee, and a number of things were discussed already in those times. Many are resolved, of course, but not all of them. But I will remain with my field for the moment, without prejudice to something could be said later in the debate, which is essentially an aspect of violence against women, and more generally gender violence, in time of conflict especially, but also in times of peace, when the level of the violence reaches the level of being a crimes against humanity. But essentially, in times of an armed conflict, this is a real problem. And we see now, it's enough to read the newspapers, there are mass violence against women in many countries where there are conflicts. This was probably always the case in armed conflicts in the history, simply did not came to the surface, did not came to the attention of the world as a problem, actually. It was simply something that was connected with the war and was accepted as such. But luckily, this is no more the case, and this is a real problem that has to be taken up. The international tribunals, criminal tribunals, took it up. But it was a big challenge at the beginning. It was not a simple question. It was not a simple question because the main challenge, initial challenge, was that violence against women in conflicts is not taken up in the Geneva Conventions as a grave breach of the Geneva Conventions. So there is no rule as a basic rule on these matters. The Nuremberg Tribunal did not consider this especially. In '49, when the Geneva Convention were adopted, there was nothing on this specific problem. If you look at the list of the grave breaches of the conventions, this problem is not mentioned at all. Of course, under some of the headings of the crimes that constitute grave breaches of the convention, one can put also the violence against women, but it's not selected as a problem by itself. And the statute of the ICTY did not mention rape, for instance, in as far as war crimes are concerned. Mentioned it in crimes against humanity. but not in war crimes, because it referred to the Geneva Conventions. There was a catch-up clause in the statute, however, according to which, in general terms, violations of the laws and customs war could be taken up as a crime. A very generic rule, referring to customary law, essentially. But of course, assessing customary law in an area where there is no precedent is not the easiest thing to do. And it is shown that the prosecutor herself didn't dare to raise the point. And the first case that was brought before the ICTY was a case under the heading of torture. Because torture is well known, is a crime. And you can subsume, if you want, a case of violence, a case of rape under torture. It's an ill treatment, so it can come under torture. And to be safe, the prosecutor went that way. Was a case in which the torture was a case of rape. But the rape was not mentioned. And was mentioned, of course, as an evidence. And the tribunal had to deal with that, trying to find the elements of rape, nevertheless, but at the end, it convicted on torture. In the following case, the Konarec case, the prosecutor took courage, in a way, and but still, with doubts, brought cases of mass rapes or multiple rapes of victims in as torture, following the previous case, so was sure to win the case, and alternatively as rape, as a war crime, although it was not mentioned, and so could be brought in only under that general clause that serious violations of customary law can come before the, but the elements of the crime have to be found, invented in a way, or described or taken from customary law. And putting it alternatively, it left the court in the position to decide whether to go for torture or go to rape. But it added one word to alternatively. It said cumulatively. Alternatively or cumulatively. And that was an extremely good message, because one could come to the conclusion that a specific case of rape could be torture, because all the elements of torture are in. It could be at the same time, although it's one act, could be also rape. So could lead to a cumulative conviction. This left the tribunal in some difficulty, because it could be easy to go for torture and go and follow the previous case law, or decide to go differently. What prevailed at the end was the idea that a decision, a criminal decision, has to describe completely the criminality. So one couldn't just subsume rape into torture and not delete the torture and go to rape, although that could have been also an option possible. And at the end, the description of the elements of the two crimes was determinative. And the tribunal took an approach to multiple crimes with the same conduct. That is an approach that is followed by many courts, including the Supreme Court of the United States. You start from the law. If the two crimes have common elements, but each has a different element, these are two crimes. If there is only one of the two has an additional element, the other comes as the included crime in the one that has the additional element. And describing the two, the tribunal came to the conclusion there was one additional element, both in torture and in rape. I mean, the physical penetration in rape, which is not necessarily in torture, and in torture, the intention to get something out of the person tortured, which is in the notion of torture, in the convention on torture, but is not in rape. Diego knows it better because he deals with torture all the time. Being rapporteur on torture. So at the end, the tribunal came to the conclusion to cumulative convict the accused the three accused for torture and rape. This was extremely important, not just for the conviction as such, but was extremely important to single out the sexual crime as a specific crime, and not as a crime that come under a different chapeau or other crimes. And so to give a certain independence to the crime, and also to draw the attention, because on this, it's very important in that respect. And so to have the law progress on this matter. And then in subsequent cases, this was applied constantly. So there was no problem in applying the cumulative conviction in case. Of course, as it is a one act, the same act, that leads to two crimes, at the moment it imposed in the sentence, you take that into account and don't give two full sentences, but reduce a bit the sentence to take into account that it's one single act and not two acts. So this was a big step forward, and the law now exists, at least. That doesn't mean that the implementation of the law here, I join my colleagues, is full. It's clearly not full. There's clearly much to do on the level of the implementation, but at least there is a law, which is customary law and can be applied anywhere. The other extreme point, I mentioned only this new case, is a case of the Rwandan tribunal. The Rwandan tribunal, in the same years, slightly before, had to deal with case of rape. You must know that in the genocide in Rwanda, rape was a constant feature of what happened. Women, thousands of women were raped systematically, and even worse than raped, because they were not just raped, they were mutilated, they were all kinds of things. I mean, if you read the judgments, if you hear the witnesses, it was terrible to listen to them. And the point was that the case was essentially a case for genocide. And here the judges there had a fantastic idea in a way, because they forced a bit the interpretation of the Convention on Genocide and included sexual violence, gender violence, within the notion of a means to commit genocide. This is the Akayesu case, it was decided in '98, in which the chamber decided that genocide can be committed also through rape. Of course, there were the killings at the same time. Many of the women were killed after being raped also. But the idea of genocide requires a physical destruction of the intent of physically destroy a group. And there are paragraphs in that decision, Akayesu, in which the court explains how through these systematic rapes you destroy the people. And in fact, is what happens. I mean, I heard, not in that case, but in the case in the ICTY, in the Akayesu case, I was only on appeal, so I didn't hear any witness. But you see the people that are having gone through this systematic and widespread violations are destroyed. There are no more people, in a way. There are not more persons. And my reflection when I heard this is that these women that came to give testimony were the strongest, the top of the iceberg, but also the strongest part of the women that had been witnessed, because they had the courage to come before a court and in public say what happened exactly in detail. Many did not, probably, also because, especially in the ICTY, most of the victims were Muslim, and if raped, they would be excluded from their community, their family. So they tried to minimize what happened. Just to mention one, one extreme case, the prosecutor, to prove a rape, brought a certificate of a hospital where that victim had aborted, had given abortion. And the answer of the victim was, it's not true, this certificate is fake. I was beaten, but I was not raped. And there was the evidence. There was the certificate in the hospital. So she had been raped, in fact, but didn't want to say it, but not to be excluded by her community. So it's sometimes the testimony is an extreme thing. But to come back to Cayesu, that decision is extremely important because has drawn the attention on a phenomenon that puts the rape strictly in connection with what they consider the crime of crimes, so the genocide. And it was a good bench. By the by, in that bench there was a lady that was later the president of the Tribunal for Rwanda, Navi Pillay, and then was the High Commissioner for Human Rights later on. And this was a very good approach, and that too consistently has been applied. Now is law. This is clearly law, although the interpretation of the Convention on Genocide is a bit stretched, but is an interpretation. And if the courts apply an interpretation, it becomes necessarily the law that has to be applied in the long run. I don't think it will be discussed anymore. Although, and here I join Madame Simonovic on the question of implementation, there is always some resistance in doing that. In one case, for instance, later on in the Tribunal for Rwanda, there was an acquittal of a person that was already convicted for genocide. There was one episode of sexual assault as a means of genocide, and although this already had the intention to commit genocide, it was acquitted on appeal. Had been convicted following Cayesu, was acquitted on appeal with the argument that that case of a sexual assault was, I take the word that will shock you, was opportunistic. If you introduce that idea in violence against women, then when it is opportunistic, it's not a crime, well, then you delete the problem. But it's not a way of deleting it. But 4 judges, appeal judges, went for acquittal on that reason of opportunistic. One judge said no and wrote a dissent, but it was me. But simply that. I couldn't do more, of course. I couldn't go beyond and against the other 4. But it's simply a word that should not be used. You can use other words maybe to excuse a conduct, but that's clearly the word that cannot be used in a particular case. So this is the issue. I mentioned one small issue, a big issue actually, which matches a bit the problem of the new instrument that you were mentioning earlier. One of the problem of this gender issues is that now that the law has been developed by the case law, would it be useful or good to take the gender violence out, to single it out from the crimes against humanity and the war crimes, and make it a specific type of crime? You see, what happened with genocide? Genocide at Nuremberg did not exist. Even the word does not exist. So came under the general chapeau, crimes against humanity. Then there was, with the Convention on Genocide, the idea of singling it out and make a special category. And now all the legal instruments, including the statute of the International Criminal Court, have as category of crime, war crimes, crimes against humanity, aggression, genocide. Genocide is a special category. It's no more within the crimes against humanity, can be committed in peace and in war, so it's a separate category. Torture is going the same way. Many lawyers consider that torture, which can be a war crime, can be a crime against humanity, but for the type of crime is in a way selected and singled out and is a special category of crime. Would it be a good idea, I put just a question, would it be a good idea to start singling out the violence against women, but maybe including violence in more wide in gender violence, and children, of course, too, and make it a special category that goes out of the other crimes? It's not to be proved as war crime, crimes against humanity, just a more independent category. Perhaps might be useful to deal with the problem in a more systematic, coherent way. But it's just a question. Or maybe the law will evolve in that sense anyhow, but it's just a possibility. I close on that.
Thank you. Well, do you have a comment on it? Do you have a view on this question of whether or not it makes sense to...
I'm sorry, just commented a bit.
Put you on the spot.
This is an interesting proposal, and I would like to mention that new general recommendation 35 from Sedo Committee on Gender-Based Violence Against Women is also acknowledging that violence against women could amount to torture in specific circumstances. I think that it's extremely important to see that rape is happening in peacetime, in families, behind closed doors, that rape is not properly addressed in different countries in their legislation. And we have to see connection between situation before the war and what is happening then during the war. My feeling is that now at the global UN level, there is strong focus on women, peace and security agenda. And it is good. But on the other hand, somehow we are not sufficiently addressing all those forms of gender-based violence that are happening every day, everywhere, to almost every woman. When I visited Bahamas recently, I was surprised that there is still acceptance of marital rape as something that is allowed, not prohibited by law. They have pieces of legislation that is prohibiting rape, but not for those that are in marriage from 16 years old on. And I was surprised, even NGOs were not raising this as a problem. And I was asking NGOs, how come that you are not pushing for this change? And they told me, it's very sensitive, we are trying to do it differently and so on. And in my press conference at the end of mission, I stated that this should be changed. And after that, when I left the country, there were newspapers, articles, discussion started. And I think that it is important to have this type of discussion. What should be prohibited at the national level? What are those types of gender-based violence that should be criminalized, what should be in other pieces of legislation, what are those implementation tools that we need. So we have to see this continuation of violence that is happening behind the closed door, that is considered as acceptable, domestic violence and so on, and we have to challenge all those stereotypes and acceptance of violence, normalization of violence. And only by this we will be able to have better situation when we are reaching situations of conflict and war. Now, when countries are only focusing on those fragile countries that are now dealing with women, peace and security, they are focusing only on Security Council 1325 resolution and, let's say, criminal courts that are established to deal with situations after that. So those countries never had proper laws that are dealing with violence against women and gender-based violence and so on. So we have to see in the future how to connect this better and better focus on gender-based violence against women. It's really needed. Should it be singled out in a specific provision, or I am not thinking about convention, but I'm thinking that integration is also important, because we have to see violence against women as something that is coming out from different forms of discrimination against women. So connection between discrimination and violence should be clear, but clear focus is also needed. So point is really important, and it is for discussion. Thank you.
Dr. Shimovich, do you have any questions for Dr. Fokar before we turn to the audience?
Yes, because it is interesting, because you were previously in Human Rights Committee and after that in ICTY. And this division between human rights law and humanitarian law is unfortunately visible. And for example, I am focusing on human rights perspective, and from that perspective we are trying to say that humanitarian law and human rights law should be applied jointly, that there are compatible fields of laws and so on, that, for example, Sedo Convention is applicable in times of war and so on. Did you have any kind of experience or possibility to apply also human rights law in cases that were dealt by ICTY or not?
Well, to a limited extent, actually, because I had a long experience in human rights, and it came natural for me to apply human rights law. But that was not the case for others, because the two fields went separately, grew separately. And it's very rare that one has the training in both fields. So I saw many issues of human rights, not necessarily only this. The human rights law has been set aside, neglected completely in the case of the tribunals. I wrote many dissents on this, but just dissents. Couldn't persuade colleagues, because criminal lawyers do not care very much of human rights. Prosecutors do not care of human rights. They are not educated on that. If one is educated on human rights, I don't know which is your experience, of course. My experience is that you end up maybe of overdoing, maybe, but you see human rights everywhere. And if there is a situation that comes under human rights, you immediately try to apply it. And also in normal life, it's a mode of thinking, human rights. If you have an experience, it's difficult to get out of it, actually. So you end up applying it also in humanitarian law. It's in the two fields interrelated, really interrelated, and they are interrelated because, peace and war are unfortunately status now that are not like in the past. Maybe we were fully separated. Now with the asymmetric conflicts, it's all mixed, essentially. So you have to apply human rights law, I think, to complete humanitarian law, or vice versa. but the courts, the international courts, tend to apply essentially humanitarian law and nothing more. That was also the mandate. If one looks at the mandate of the ICTY, the report of the Secretary General to the Security Council in sending the draft statute explicitly says this tribunal will have to apply rules of IHL. Doesn't mention human rights at all. So it's a normal thinking, this. It has to change, but we have to try to change it.
I'd like to ask a question sort of building on that when we're talking about different areas of law. The fact that the ILO is considering a gender-based violence treaty or a recommendation, we'll see what happens. I was wondering, so to what extent does labor law come into the analysis, right? I mean, you've got the ILO taking up this charge to address gender-based violence, right? To develop an instrument that looks at a full. I mean, and they're, as I understand it, conceiving of violence very broadly, right? Not just physical violence, not just psychological violence, but also structural violence, right? All the things that.
May I complete the question? Add something to the question because I don't know it. Is the idea to have, or allow to have a recommendation or convention, whatever, an instrument on violence on workplaces, and that's one thing, or in general connected with work? Because these are two different issues. I don't know if the intention is to limit it in a way to workplaces or take up the question of the violations due to the working environment, because this will bring refugees and the work of migrants, and it's much wider.
I think it's intended to be quite broad.
Okay.
Right?
I'm not following closely, but if we look at Sedo Convention, it is clear that discrimination against women and violence against women in a workplace is covered by Sedo Convention. So it is already addressed by a convention that has been ratified by 189 states. So obligations are there. And there are recommendations and concluding observations from Sedo Committee with respect to countries in which, for example, sexual harassment at the workplace is not properly addressed. There are norms there. There are also jurisprudence coming out and so on. Nevertheless, I know that it's an ongoing process at the level of ILO, and sometimes it's good to have compatible, let's say, instruments that are addressing the same area as Sedo Convention. For example, there is specific article in Sedo on trafficking of women, and there is convention on trafficking. So we have to see how to have compatible instruments, but in the same time to preserve what was developed up to now and to uphold standards that we have at the level of global instruments like Sedo. It is important to also see that this ILO convention or whatever it's going to be, it's not going to be global convention on gender-based violence against women. This global convention on gender-based violence against women was discussed by my predecessor and then addressed by my mandate. And in long term, something that was coming out from those submissions that I have analyzed was possibility maybe in the future to have optional protocol to Sedo Convention that would deal with gender-based violence against women. So that would be then legally binding instrument. If the key problem is legally binding instrument, then that could be solution. But in the meantime, since new general recommendation on gender-based violence has been adopted recently by the Sedo Committee, we have to see how states will proceed with implementation of that specific new general recommendation. And I think that sexual harassment is also in this general recommendation 35, but nevertheless, if ILO is having positive signals from states that they would support something stronger it would be good to have something stronger on this specific area related to work in order to have focus on this area, because this area is important field of women's life. We have situations when we are seeing that women are not sufficiently protected in field of work, and that could be then added value. And I think that we have to see what is going to be decided by states, because at the end they are deciding in those areas when they are putting forward their final solutions.
So we are at the point in the panel where we can open it up to questions from the audience. So I invite you to raise your hand, and if you could introduce yourself very briefly and pose your question. We would love to hear from you. Any questions from the audience? Christina.
My name's Christina. The microphone. It's so stressful. Okay. My name's Christina, and I'm a student. I'm a graduate of Diego and Claudia's program. Recently, I am wondering, and I realize that this is kind of the whole point of tonight's discussion, but I'm wondering if there is an agreed upon definition of gender-based violence. We all love to use that phrase, but can people agree on what it actually means? Because, okay, of course, something like FGM, right? We probably all can agree that that is gender-based violence. But, I don't know, like negative attitudes towards LGBTQ people and, you know, not conforming to gender roles, is that gender-based violence? So I guess I would just like a little more clarity, even if it's just like, well, there isn't an agreement, and good night. Thank you.
May I respond? Thank you. This is a very good question, and this question was discussed in this efforts to develop new general recommendation number 35, because if you look at definitions, there is definition of violence against women and gender-based violence in United Nations Declaration on Elimination of Violence Against Women. There is another definition produced by Sedo Committee in General Recommendation 19 on violence against women. And basically, Sedo definition is saying that gender-based violence against women, it's violence addressed against women because she is a woman, or violence that addressed women disproportionately. In addition to this declaration on elimination of violence against women is saying that it is any act of gender-based violence that is causing harm and influencing enjoyment of human rights of women in different areas. So we have to use those definitions that are accepted. And if you look at the Council of Europe new convention on violence against women and domestic violence, there you will find definitions of violence against women, definitions of gender, and definitions of due diligence. And definition of violence against women is what I have stated. Violence is, first statement is that violence is a human rights violation and form of discrimination against women, and this is recognition of work done by Sedo up to now that is seeing violence against women as a form of discrimination. And then there is clearly stated that it is any act of gender-based violence. This is what I have already mentioned. So I think that definitions are there, but they should be maybe better explained. New General Recommendation 35 is going in that direction of giving more substantive knowledge and explanations about use of this terminology. And unfortunately, we are seeing today that there are some movements that are opposing use of a term gender. I don't know if you're aware, there are movements in different parts of Europe and Latin America that are now using misinterpretation of term gender in order to read under this term gender ideology that is ruining families and that are basically opposing, for example, ratification of Council of Europe Convention, Istanbul Convention in some European countries, and in some Latin American countries in different referendums, including referendum in Bahamas. Under this gender ideology movement, they have opposed changes of the constitution and inclusion of prohibition of sex-based discrimination. You see, so there are different movements that are challenging what we have developed up to now, and for that reason, this knowledge about instruments that we have is crucial, and we are not sufficiently promoting, we are not sufficiently learning about, for example, this new General Recommendation 35. I have not seen big promotion of this General Recommendation, and this something like this is needed if before we start saying we need new instruments. So let us see what we have, let us see what are those implementation gaps, let us see what countries are not really doing at the national level, what they are kind of forgetting to do, what they have promised to do when they ratify those treaties, and how to push them in that direction, because they do have accountability, and we have to see how to use those mechanisms better. Thank you.
Yeah, not to say that, just adding something, that the conventions, many conventions of this kind, have a huge amount of reservations. This is also for the Convention on Non-Discrimination, the Elimination of Discrimination Against Women. It's ratified by all countries almost, but the countries that lodge reservation is one of the conventions that has more reservations, actually. And the Convention on the Right of the Child goes the same way, in a way, ratified by everybody, except this country, I think. But yeah, that's the only country, now two. Somalia is not ratified too.
The Somalia
Now it's ratified, now we ratified, yeah. So it remains only the United States. But, okay, but it's a special situation. But there are many countries that presented that had reservations. So that too is something that has to be overcome. When thinking of a new instrument, should be an instrument maybe not allowing for reservations.
Yes.
Either, but hi, my name is Iveta Paik. I actually was a professor at American University for a while, and now I'm in private practice. But I do a lot of pro bono cases for CPOs, well as civil protection orders here in DC, with women who are battered by their partners. I like your idea of a treaty. However, honestly, I'm not sure if that's going to happen, for the reason because you kind of said that CEDA, it's the most reserved treaty. And when we look at countries like Russia right now, United States, where public figures are saying that it's okay to do certain things to women or say certain things, and we have in Russia where the actually domestic law has been reversed recently, where it's okay to beat your partner now, and used to not be. I actually wrote a paper when I was doing my LLM at AU as well, many years back. So my question is, is it really realistic, and maybe wouldn't be better approach to actually not only create law, because laws are created but not always followed or enforced? Wouldn't it be better to maybe do some kind of domestic laws where the enforcement is actually enforced, I guess, and maybe do it more on a level? Because I'm thinking, for example, some countries will not agree to such thing because they might not agree on the definition of rape, sexual harassment. We have some countries where women actually are, if they're raped, they have to, or they're made to marry their rapist. Recently, there were many cases like that. So my question is, really, yes, it's a great thing to think about it, but can we do something more immediate, something that actually, not necessarily the great UN bodies and other international, but even people in different countries can do something to actually either move the legislation or anything else that you could recommend?
Was it for me?
Well, for both.
Okay. Please.
Well, if you want, but you can know better the situation now. You see, I think you are right in a way, because again, what we need in human rights is more than instruments. You need implementation. And having domestic laws is a form of implementation of the international instruments. So it's not the concrete implementation, but it's a form of implementing, because the national law will be certainly applied more by the judges, by the authorities, than the international instruments. So insisting on implementation is certainly important, but I think that, for instance, the committees, the committee of Sedo is insisting on the implementation, also in advising when the reports come, how the legislation should be internally. So it's, there is some effort to do that. It took time, that too, because, for instance, Sedo didn't have until, I don't remember exactly the time, didn't have the individual communication procedure at the beginning.
Until 2000.
2000.
Yes.
But I remember when I was the Human Rights Committee, each time I went to New York, there were meetings to try to persuade states to have an instrument. And you know what was the reasoning of states against, and of all kinds of states, speaking of Western, non-Western, was that, well, we can't have an individual communication procedure because in the treaty there are rights that are justiciable and rights that are not, which is true. And so we cannot have individual communications on that, because there are some rights that cannot be the subject for individual communication. And my answer, participating in this debate with the states, I said it's exactly because there are rights that may be justiciable, those who are not, that you need a body to decide on that. So it's simply that. So you have to have the communication in order the body will decide this you can. But this applies to all the human rights instruments. Even the Covenant on Civil and Political Rights, which said all is justice, it's not true. There are a lot of things that are not. They require implementation, they require new laws and so on. So but nevertheless, you need a body that decides how the implementation should be done. So at the end, that prevailed. But I was surprised that there were not countries that act against women, but countries that were defending women. Nordic countries of Europe, they were against because of that reason, you see. So the implementation at the national level is not easy, but I am sure that the UN bodies, and certainly the rapporteur, is insisting on domestic legislation. She made an example on Bahamas just a moment ago, to have a law to take up certain issues. So sometimes I think that the world would be better if we just implemented the Universal Declaration.
And if I may add, it is important to see that those human rights instruments are evolving over time. Yeah. So they are not static. They are under interpretation of the Sedo committee. And also new instruments are added, like optional protocol to Sedo that allow the individual communications and inquiries. Today in my class we have discussed inquiry against United Kingdom and Northern Ireland on reproductive rights of women. And those recommendations are really extremely important, not only for this country, but for many other countries with restrictive laws in this area. So they are really spelling out how to properly interpret Sedo and apply a level of rights related to abortion in a proper manner. With respect to reservations, I would like to say that Sedo is the second treaty with respect to number of reservations, but this is changing because Now we are seeing the countries are withdrawing and narrowing down reservations. And something else, what I have seen while I was in the committee, even though there are countries that are putting impermissible reservations, because convention is saying that those reservations that are contrary to the purpose and object of the convention are not permissible, and they are putting reservations on Article 2 that is dealing with substantive equality, and also on Article 16 that is dealing with equality within families. But even those delegations, when they are coming before the Sedo committee, they are not saying we are not going to discuss this because we have reservation. They are discussing issues related to violence against women, discriminatory laws, and everything else. And it is a procedure. So now Sedo has also 3 sessions per year, what means that Sedo is able to examine more than 28 countries per year. And this is turning this body into a body that could really look into follow-up. 4 years after examination of one report, next report is coming in, and this is changing everything. Now I'm looking as a special rapporteur into possibility to have through Sedo follow up to my recommendations, because I'm using Sedo recommendations when I'm traveling to the country, and Sedo should use recommendations from special procedures that are relevant for specific countries. So we have to see how to develop those mechanisms, how to make them more visible. And also in this digital time, everything is different. I think that now CNN should sit in room when states are reporting how they're implementing human rights. Because all those commitments should be very public commitments. If they are saying we will change this, and they are promising a lot when they are answering questions and so on. So they should be screened all around the world. So I think that we are in a global world. It should be a very transparent, visible process, because now it's clear that we are going in direction when no one is willingly saying violence against women is okay. They're still maybe thinking it, but not saying it anymore. There is a lot of talk about violence against women. There are a lot of focuses, but we still have to have kind of mechanisms that are mandated to be able to fully produce what is required from them. And here we have to see how to support this process better. Thank you.
Yes. Go ahead.
Hello. Oh. Hi, my name is Lucette, and I am an incoming 1L at Washington College of Law. Hi. And I'm not sure, because we weren't really talking about this earlier, but just in case, last week on Friday, Jean-Pierre Bemba, former vice president of the Central African Republic, was acquitted of all charges by the ICC appeals chamber. And that case is very relevant to what we were discussing, as it was the first ICC conviction that recognized sexual violence as a weapon of war. And I was just wondering if you have any comments on the potential impact this acquittal will have on either future legal proceedings or politics regarding any of the conventions that we were discussing.
It's a good question. The issue is that I did not reflect completely on the text. I went through quickly to see why the acquittal took place. In principle, it shouldn't have much impact on the sexual violence as such, because I understand that the acquittal on appeal does not depend on that. Depends on the interpretation of the superior responsibility, essentially. So the point is that factually, and it's all factual, on whether Mr. Bemba, who was in one country and the military operation was in a different country, could really intervene to prevent the commission of crimes. So it's a question of responsibility. The superior is responsible for crimes committed by the subordinates if it knows of the crimes, is aware the crimes are being committed, and or will be committed or have been committed. It does not intervene to prevent the crimes, to take the necessary measures to prevent the crimes, and or to punish the perpetrators. Now, this is the issue essentially, and I understand at the end the chamber came to the conclusion that he could not intervene, didn't have the means to intervene because he was in a different country. I see a flaw in this because if a commander is acquitted because he conducts operation in a distant place, and this is enough to say he couldn't intervene, well, at the end, all the commanders today will be acquitted because they will be distant from the place of operation, be more and more distant. If you make cyber operation, you are very, very distant. And so you actually will not be responsible anymore. And that's a bad development of the law as such of commander responsibility. I may imagine they were led by precedents at the beginning of the last century after the war, in which somebody was convicted and couldn't reach the subordinates, couldn't give orders, could not intervene in Japan. In the Philippines, there was a Japanese general. And that was caused some criticism, because it was like having strict liability for the crimes. But the point is that I think the decision should be criticized also because it made a factual assessment on appeal, intervening too much on what the trial chamber had assessed as facts. And as a matter of principle, facts should be assessed by the trial chamber, not the appeal chamber, because the appeal chamber does not hear the witnesses, so does not hear the evidence, and is not in a good position to make a decision on the facts. The trial chamber is much better, in a better position to, because hearing the evidence is one thing, reading the evidence or the proceedings is not the same. Is not the same. Any judge that has had the two experiences understands that when you are on appeal, you should not intervene too much, because the trial chamber knows exactly better, makes a better decision, because it has the record and has the direct testimony, received the direct testimony of the witnesses. The appeal chamber does not have that, so intervenes to correct a decision, frequently does it wrongly. That happened also in the ICTY, that the standard sometimes of appeal was too much intervening in the factual. And unfortunately, the ICC is taking the same approach to go too much into the facts. But the outcome is negative, because this was a case in which what everybody knows, that rape can be a means of war, everybody knows that, but was never brought about clearly in a case. I mean, all the cases you had in the ICTY, we knew exactly there was a means of war, but not necessarily you could say, because it didn't have the case specific on that issue. It was not brought by the prosecutor. Now it was brought by the prosecutor, was a good occasion to say it, to define how it is the means of war, rape, as Akayesu said, as a means of genocide. So it could be done, complete the picture in a way, or extend the picture. It's unfortunate this has gone. But the case may remain, because although it has been reversed, the trial decision, if it is reversed for other reasons, that assessment in a way can be quoted nevertheless, although formally is annulled, is deleted, of course. But that's a provisional assessment of the member. It's very unfortunate. It's very unfortunate it went that way. But
Hi, I just first wanted to thank ASIL for putting this together for the organizers. This is a really wonderful event, and of course to the speakers. My name is Carolyn. I work for an NGO in town that works on the protection of civilians in armed conflict. And my question is actually directed to both speakers and kind of connects a couple of themes that we're hearing today about the question of implementation, and then also the question perhaps of accountability, and for me a little bit about education, and I'll speak about that a little bit. When we talk about implementation with respect to national legislation, or the lack thereof, assuming that there are, for the states that do have national legislation, I'm curious about the disconnect with respect to prosecution of cases and the difficulties in evidence in proving, right? And how do we link and improve, assuming that victims are willing and able to bring their cases forward, how do we ensure that prosecutors are equipped, perhaps, education both of judges, and I'm curious about your perspective, Judge Pokar, on, especially in the opportunistic example, and or when you said that certain folks might not even have training on human rights, is there training on how to adjudicate these kind of cases? From the enforcement side, do law enforcement officers, is there training within societies to ensure that when these cases, assuming that there are laws, to enforce them can actually be brought forward as strongly as possible for a conviction to have things held accountable?
Thank you. This is a very important question, and it is going in directions that we have not yet addressed. So it is important to look into national laws also with respect to their implementation by judicial system, prosecutors and judges. And here there is a huge gap in terms of education of legal professionals with respect to international law and human rights law accepted by the country concerned. What I'm seeing is that lawyers in number of countries, in majority of countries, they do not have this type of education. And at level of treaty bodies and special procedures, we, on the other hand, expect from them to know how to do it, to use jurisprudence developed at the UN level, to use those cases as precedent cases, and to be informed. So you will see that in number of concluding observations from all treaty bodies, there is a recommendation that there should be training for prosecutors, for judges on Sedo Convention, on other human rights treaty and so on. But this is not yet properly happening. So this is something that should be done. From my side, as a special rapporteur on violence against women, I have launched initiative for establishment of a femicide watch, or gender-related killings of women watch or observatory in each and every country. And with that proposal, I have suggested that all states should have data on homicides, and they do have data on homicides, but they do not have from data on homicides specific data on killings of women or femicides data. And why is this important? This is first step that I think is crucial and should be done by states in order to see, for example, in domestic violence cases, what is percentage of women that are killed and what is percentage of men that are killed. Because numbers are really showing that this is huge field in which women are disproportionately victims of gender-related killings. For example, for 12 European countries, it is clear that when you have 10 persons killed in the context of domestic violence, 8 of them are women. So dangerous place is home for women in terms of those gender-related killings. majority of countries there is a challenge how to collect such data. And at this stage it is clear that we need to have collection of data by those that are collecting data at the level of police, judiciary, statistical offices and so on, that are showing relationship between perpetrator and victim. And our systems in different countries, they do not have such data. Because this data that is showing connection with perpetrator and victim is showing if it is intimate partner killing or if it is family-related killing. And when we have this big category, then we are seeing that all killings of women in different countries, approximately 70% of killings are those family or intimate partner-related killings. So that is showing numbers, and I hope that in the future we will have comparable numbers for countries in order to see what is femicide rate, what is going on there. But then second step that I am advocating is establishment of a national expert bodies, interdisciplinary bodies that would look into those cases of killings, because they are not only numbers. Those are stories, those are women with families, those are concrete cases in which police was called, what police did, what was the major problem at the national level, what are those gaps that are showing out from number of cases, because we have to see, for example, in small country you have relatively small number of cases, my country 17 to 80 cases, but maybe some other countries of a similar size have higher or smaller number of cases. So through analysis of cases it is important to see where is the problem. Is it prosecution, is it police force, is it lack of shelters, or is it insufficient protection orders? And there are differences in different countries that should be properly addressed. But first we have to see how to start from bottom-up approach and how to see what are those major gaps. So, and here I'm coming back to this education of police force, this, for example, risk assessment that is done in some countries but not in all countries, this education of prosecutors on domestic violence cases. They need to recognize what is happening in such cases. Then a prosecution even without charges pressed forward by victim. In many countries, when victim is withdrawing charges, the case is stopping. Now there are recommendations coming from Sedo Committee, and Council of Europe Convention has specific provision that even in such cases, if there is serious violence that happened in that case, prosecution could proceed. So there are standards that are now going in direction of being more detailed, more concrete, but for that real education is needed. Thank you.
I don't have much to add. I think this.
Do you have thoughts on our, the international, are the judges within international tribunals educated in specifically?
Well, not really. I mean, but one has to start earlier to do that, because the moment they are judges, it's difficult to educate a judge. I mean, we tried, for instance, I tried when I was president to make a program to educate the judges in Bosnia to deal with cases, because we had to refer many cases to them. Most of the cases were there, and they were not prepared to do that. They had no notion of humanitarian law or whatever. But the moment of training judges, you have immediately a resistance, because a judge says, well, I'm a judge, I know the law. I don't accept being trained by another judge. So the only way of doing it for me was to have a program with UICE that I sponsored, promoted, to have peer-to-peer meetings. So you have to go there and say, let's share experience. You train them with that, of course, but you cannot tell them that you are training. So that's, that's the point. You must start the education much earlier. When you form the judge, when they become judges, when they become prosecutors, but when they pass exams for that, they should already know the things. So it has to put in the programs, these things, which are not in the programs. And I share many lawyers do not, even the counselors, do not know even the the remedies that are available at the international level. I don't know, in my country now, after so many years, the remedy of the European Convention of Human Rights are known, but that's it. Sometimes it's better to go to another instance, a committee even, which maybe is not binding, but nevertheless has a different approach, has different standards, for instance. Everybody in Europe has the feeling that the top of the standards are the European standards. It's not true. You had instruments that have higher standards in many respects, especially on discrimination, by the by. The European Convention doesn't have a rule on equality before the law.
We are unfortunately out of time. I'm getting the signal. So if you could join me in thanking our speakers for devoting time to this.